Okay, I'll start the discussion then. First of all, thank you really much, Professor Pistor, for this really interesting talk. Thank you also for sending us the first chapter of your forthcoming book, Capitalist Law, or The Law of Capitalism. Me, Khushi and Sara will present the discussion. I'm Romain from France. Okay, first a few words about how we structure this presentation. First we'll do a sort of recontextualization and summary of the chapter you sent us, and then we'll dive into some other views about what the literature says on the topic, like the states in the climate crisis, or the role of technology in regards of the emerging labor contracts, and also thinking post-capitalism, how this approach might or might not help us to think about post-capitalism. And I cannot. Okay, yeah, that's good. Okay, just a quick word about the history of capitalism. Okay, as you understood, obviously capitalism is not just an economic phenomena, is not just like goods and services, labor relations, private property, but it's a legal system. It's legally coded. It's basically based on fundamental legal modules, such as property rights, contract law, guarantees, company and bankruptcy law. That transforms ordinary assets, as you said, into private capital, productive capital. Without these legal modules, these assets wouldn't produce as much wealth as they do under these capitalism regimes. So the history of capitalism can be read through the lens of the legal systems. Like in the 18th century, for instance, the core of the new capitalist regime was the state debts, and the capitalists were the financiers who invested in state debts. That's why in the 1830s, some French political theorists introduced the capitalism words to refer to these financiers who accumulate state debts. So capitalism, takeaway, co-evolved with the modern states.
And just to ensure that, just a quick repeat, so we saw that there are like three major characteristics of this capitalist law. So the main motive is to basically appropriate the social resources for the private gain, and it is done through three major mechanisms, which is private legal empowerment, decentralized access to means of coercion, as well as legal arbitrage.
Okay, and it's important to keep in mind that this capitalist law has basically shaped capitalism as we know it today, of course, also on the international level through enforcement of certain legal systems on the rest of the world. Law has been a central means also in colonialism to subject local populations and enforce debt contracts on them, claim property rights over the resources they own. And today this continues in a slightly different form with the imposition of best practices on other countries. And yeah, institutions like the IMF and the World Bank and all those nice institutions play a central role in that, which is why a legal institutionalist perspective can really provide a very useful lens to understand law and the economy with a special interest in those power relations that really shape the law. And with that, we'll try to dive into our discussion. I'll spend my time on the climate crisis and the role that the state plays in there. So you make the point that we, I guess, also all feel in our daily lives that capitalism is a very crisis-prone system. And the only reason why capitalism is not yet disappeared due to all these crises is basically because social resources are mobilized to contain those crises by states, mostly. The two central resources being money or the law, as we also just heard. However, if we look at the climate crisis as one of the major contemporary crises, we see that the ability of states to mobilize those exact social resources is severely limited in many ways, mostly self-limited. So on the one hand, we have really this private legal empowerment aspect that you also emphasized through things like international investment treaties, for instance, that protect fossil assets. And the second contemporary economic policy example I would like to zoom in on is constitutionalized fiscal policy, especially for the German case. So coming to the question how effectively states can mobilize law in the climate crisis, there's a really broad landscape of private legal systems through investment treaties. There's around 2,500 of those in force around the globe, and most of them have investor-state dispute settlement provisions, which means that if you as a company invest in some other country and you see your profits being reduced due to state legislation, then you can dispute that. And the fossil fuel industry has been one of the major beneficiaries of those provisions. Around 20% of all cases were in relation to fossil fuel assets, and those are also the largest cases in terms of the compensation paid out. And what we've seen in the past years is that an increasing number of those arbitrations is based on climate legislations enacted by states, which really raises the question how effectively states can institute law changes for climate action if, at the same time, other parts of the legal system corrupt those and really lead into a sort of legal deadlock. So this really raises the costs of climate actions in many senses, which can be a major issue for mostly small economies where fiscal space is a problem anyways. This is a problem that is not going to get any smaller going forward. There have been recent attempts to map how many fossil fuel assets globally are protected by some sorts of investor-state dispute settlements. And especially for oil and gas fields, this is huge. Most of them are protected by the Energy Charter Treaty. So that made us wonder how effectively states can actually mobilize the law to navigate the climate crisis, or whether this is perhaps a different type of crisis that can't be resolved by the same means that have been possible to resolve the other crises we've seen in the past decades, perhaps. There have been some very recent changes. There has been a modernization of the Energy Charter Treaty this month, for instance. There have been several withdrawals from that, which one could perhaps read as some sort of successes or little transformations. I don't know, I guess we share your doubts about how much change really is possible within that system and how easy it is to move from incremental changes in this system to a transformative change of capitalism. And we'd love to discuss about that further. A similar picture emerges if we look at the question how well states can mobilize money to navigate the climate crisis. Those are fiscal rules around the globe. We see they've been on the rise over the past decades, beautiful institutions. And one that is especially dear to my heart is the German debt brake, which has recently broken the government budget and also the government coalition. Against huge additional investment needs. There have been several recent estimates for the German economy that really try to find out how much more investment you need in all different areas of public life, and decarbonization over here is a huge chunk of that. That is 208 million additional needs to what is already planned until 2030, and this is a very conservative estimate. So taking those two strands together and coming back to the original observation that perhaps the only reason that capitalism has not yet vanished is because states mobilize social resources like the law or money to navigate those crises. We, I guess, are wondering how the climate crisis fits into this picture if we see in many instances that the usual ways in which perhaps law or the money are mobilized by states don't seem to work all that well. And why do states do that? Why do they willingly seem to hand away their possibility to mobilize those adequate legal and monetary resources? Is it just naivety? Is it something else? And given all those constraints, this really seems to be an uphill struggle. And we are wondering whether transformative lawmaking is actually practically feasible, or whether it is mostly a theoretical possibility for how system change could happen. And with that, I'm handing over to you.
Going in another direction, I will talk quickly about varieties of capitalism, because we have found that in the chapter we read and the literature we found, the capitalist law can be considered as a bit indivisible and timeless. For instance, forgetting the multiplicity of regimes, the multiplicity of varieties of capitalism, and as well as forgetting the competition law, which is a constitutive institution of capitalist markets. For instance, in the work of a recent paper of Foster and Seelen in 2024, they talk about competition law and VOC, and they highlight several different interactions between law and capitalism, because competition law actually shape the interactions of economic actors, as well as they influence deeply the trajectories of the capitalist regimes. And in their work, they found divergence between the EU and the US legal systems that leads to two different types of coordination of capitalism, horizontal versus hierarchical coordination, basically. So just to show that the capitalist law is not timeless, and there are several different capitalist laws.
And now just to move on to our third point, it talks about how there is a distinction in your paper about law versus norms. So we wanted to discuss a bit more on that. So in your chapter, you argue that whenever there is a separation of deliberate lawmaking from the social norms, there is an opportunity to at least up to some degree create alternatives or to override custom. So, and just to like conceptualize formal law better, it works through these three major principles, we can say. It is a social ordering device with a complete apparatus of lawmakers and law enforcers. At the same time, there is coercive enforcement possible. And at the same time, this coercive enforcement is also institutionalized. However, we wanted to argue that is it actually that different when norms are in play? So Malinowski would argue that even within the primitive Melanesian societies, norm was also used as a social ordering device, with elders, family, religious organizations, schools, and workplaces being, let's say, the parators. At the same time, coercive enforcement was still possible through social mechanism like ostracism as well as restitution. And these coercive enforcement was further institutionalized because norms were driving this institutionalization. And just to give you an example, it would be the Orientalist origins of law, for example, the Muslim family endowments in Algeria and India, which were, for example, called waqf when they were working. However, they were seen as static, inefficient, as well as outdated. And so law is fundamentally shaped by ideology as well as colonialism. And we can also use the ideology of Gramscian cultural hegemony to see how dismantling of WAF was not just about practical legal changes, but it was about embedding the ideological dominance over the Western norms over the Orientalist trope of the stagnant East. And it was a tool through which the societal norms and ideologies became institutionalized. So legal systems deserve attention not because they're inherently superior to informal norms, but also because they institutionalize and perpetuate the dominant social ideologies, as Gramsci and Said both would argue. And just to conclude this argument, what we are saying is it could be a false dichotomy, and maybe there is more of a dynamic impact between both laws and norms, as we have seen in Durkheim's work that even the very initial laws about theft were actually coming from the shared moral norms about theft being wrong in the first place. At the same time, laws can nudge norms, and legalizing same-sex marriage has changed the norms around LGBTQ relationships. And we also saw how it has worked out in terms of property with Gramsci as well as Said's argument. And the last one is also very much important in the case of technology, how norms can actually influence legal interpretation, as seen in the Amazon's exploitation of the consumer welfare norm in terms of lower prices, as noted by Elena Khan. So given the role of technology, we wanted to just take a more Marxist perspective, because you say that the centrality of labor in the current societies can be challenged, because how are we exploiting surplus, and technology may just remove that centrality of labor. So we just wanted to talk about the current model in late capitalist societies, which we can argue is platform capitalism, perhaps surveillance capitalism. And just to understand platform capitalism, it fundamentally relies on the drive towards more data. And every consumer is becoming a prosumer, where they are both the producer of the data and as well as the consumer of it. And it fundamentally is moved on by the disregard for privacy and also with workers' rights. And given that, labor exploitation would still be relevant and the surplus is still being exploited from the labor. However, how it is being exploited has changed. For example, there are global labor systems, and 12% of the labor force is actually involved in some form of micro work or even gig workers, as noted by World Bank report. And even when we talk about, let's say, gig workers or even like the micro workers, all of these are actually beyond the purview of law. So the need for social theory is still there, and institutions in law cannot justify it because we cannot even study them within the framework of law. So, and even the last point is, even with respect to technology, is technology actually that revolutionary? So can it actually replace all workers? Because even right now, it cannot perform abduction, and at the same time, there is always the paradox of automation's last mile. Even to automate the last task, you would need humans, so it is fundamentally labor intensive. And we have also seen that how this example of technology being revolutionary could be a bit false one, because even Amazon's Just Walk Out failed because they were basically using Indian workers to review what you were picking up. And so in a sense, while institutionalism is important, the social theory is still mattering, because to conceptualize all of these issues, especially in the current landscape, we need it.
Okay, just a last point of conclusion, because yeah, in the chapter and the literature we read, there was not a lot of stuff about thinking post-capitalism. What you did in the presentation, though, so yeah, this approach can actually help us to think about post-capitalism. Because while generally this approach focuses on the question normative and structural limits of capitalist law, for instance, Amartya and Nussbaum focus on social justice through the prism of capabilities. What does an institutional framework really allow each individual to do in terms of real opportunity? They suggest that all social and legal organizations should be evaluated in terms of the opportunities it creates for individuals to lead a life they consider worthy. So it gives justification through the democracy of capabilities as for state as an actor for change. That's also what another professor highlights, Vadron, in 2015, which highlight the role of public versus private law. Because as the rule of law is applied in a way that today favor private law, the rule of law is not doing its correct normative work. Therefore, we need to examine the prospects for a solid normative conception of the rule of law that neither minimizes nor devalues the mission of public administration. And for Vadron, it's all a matter of distinguishing between public law and private law, but as you mentioned, and he mentioned as well, and as well as Peshukanis in the presentation, all law is public law in ultimate sense, so that gives a justification for the states for democracy of capabilities and not only the law. Okay, we have a bunch of open questions to open the discussion. Yeah, the first one is a kind of a paradox we found in the arguments. Like you said, that's a law that gives power without accountability, that creates rights without obligations, and that enriches without requiring responsibility, risks losing its legitimacy. But also the main idea is that this same law was designed to favor private interests. So why does this law find itself in this paradox today? Maybe you want to...
And the second question is related to the law and norm debates that we had, that are law that different from norms given their importance, given the importance of norms in maintaining the current capitalist order, as we saw in Amazon and the antitrust case?
And then coming back to the questions raised earlier already, is this incremental approach that you propose really one that can lead to a transformative change of capitalism, given all these legal deadlocks we find ourselves in today? Thank you very much.
Thanks, yeah. This was terrific. I didn't have to come, really. They could have given you the presentation of my book as well, and these are great, great questions. Let me just just on Amartya Sen and Co. The funny thing is, I use them in my last chapters to find a way out. So it's interesting that you came up with the same ideas. But I will just focus on these questions because I think many others have questions too. So a law that gives powers without accountability, that creates rights without obligation, and that riches without requiring responsibility risks losing its legitimacy. But, and of course you're right, that law kind of was designed for it. That's what I'm saying. What I should have added maybe to the sentence, but let me try to clarify it now. This is what is missing in this sentence is the duality of the legal system. So we pretend we're democracies. We pretend that we do have collective governance. We're pretending that we kind of have the state is the representative of the people, and through the state agencies we have control over our laws. But at the same time we have created a private law that is becoming more and more autonomous of the people and their legal systems, if you want, because they can shop around, take different legal systems, create their own legal order. They need kind of a legal order. They still need the pretense that they can bring it back to some kind of legal order. But what I'm basically saying, if to the extent that people find out that the system is rigged, as President Trump likes to call it, and it is rigged, the system is rigged, but we're still pretending it's not. So it's the private legal order by design serves private interests, but we're pretending in democracies that this is part of a system that actually serves all. That's, I think, the tension I want to bring out. The second are laws that are different from norms, given the importance of norms in maintaining the current capitalist order. No, what I'm basically saying, we have to change our norms. That's where I think Sen and Nussbaum come in. And I'm going more with Nussbaum than with Sen. She has a more encompassing idea of human capabilities. For Sen, I think it's much more like a planning tool or like an observation tool. How much resources do different societies spend on advancing capabilities? For Nussbaum, it's an urgent task of creating claims also, not necessarily legally enforceable but claims, but individualized claims. And she says, so the nutshell definition of capabilities that Sen uses, which I think is helpful, is that every person shall have the right to live the life that she has reasons to value. Every person has the right to live her life that she has reason to value. That basically means somebody has to put us in a position to be able to live that life, because we have all different capabilities. It's not saying we all have to be made equal. We come with different capabilities. We are born with certain abilities, but we have the right to maximize them or use them in whatever way we see fit. Society at large has to put us into this position. It's not the state. Nussbaum explicitly says this is a claim against all. That's the direction of change that I want. That basically says we can claim from Shell, Exxon, and others that we have a right to live. You don't even have to say reason to value. We want to live, right? This is an existential right. Making that claim within the existing legal tools is not easy, but also not impossible. That's why I gave you the Supreme Court case from the UK. If you can basically say the parent companies are responsible for their subsidiaries, and next time you don't have to wait 13 years to make that case. And perhaps at some point states can accelerate by adopting this idea and putting this into law. That could help. But the idea that we just don't have to do the detour before some state that is almost completely in the hands of the other side, and always sort of hoping that the state will do this, it will not. I agree with you, it will not. But in order to do something different, we kind of have to agree where we want to go. That's where the norms come in. I don't think, I'm basically making the case all the time that law is not static. It changes all the time, and we don't see it because it's changing through every transaction that's trying to do something new. Norms, of course, too. On LGBTQ, I actually think that without the legitimization of LGBTQ rights in society, the courts would not have made that case. They would not. And currently, the courts in the United States are trying to go back against that, and they're getting a lot of resistance, just sort of even dropping the abortion right. In a society that actually has taken this for granted, has resulted in some referenda in some really conservative states going against the decision of the Supreme Court. So there's an interesting tension between the two. So when I'm saying norms, because the codified law that we have today, the law on the books, the law in the cases, is so much one-sided. Plus, I think I haven't said this in my presentation, but I hope it comes out in the book. I think the way in which law is being used for capitalist reproduction is to strip it of all its norms. To basically use it as as an arbitrage device that is pure black letter law. because you don't think about the purpose of the law, you don't think why it was put in place, you don't think about for whom it was done. A person is a person is a person, so a corporation is a person, so it can claim all the rights as other persons. That's the trick, right? And what I'm basically saying, what we need is to say, actually, it's about humans. This life, this is about humans, and we have to claim our rights, and not only from the state, we have to claim it against each one of us, and of course against corporations. That's the kind of normative change that I'm hoping for, looking for. I can't dictate it. I can only hope that it comes around, and yes, it has to fight Gramscian hegemony, of course, it's everywhere. But I think there are also many little pockets where it's happening, and that kind of gives me a little bit more hope. Is transformative lawmaking only a theoretical possibility or practically feasible under contemporary conditions? So, I'm familiar with the varieties of capitalism literature, and I think there is more space in some jurisdictions than in others. Katharina Thielen actually came to a workshop where we discussed my manuscript in April of this year, and she also gave me lots of examples, like in Sweden, when you have unionized labor, and then you have Elon Musk going to Sweden and saying, we will not do a collective contract. We just will not do a collective contract. That's what I'm saying. That's right. You have these different variations, and we have seen them for a long time. Germany has had co-determination since the 1970s. Volkswagen is nonetheless going to close, lots of shops right now. So it's part of a broader regime where these little variations on the ground don't matter so much. One issue, though, I take from your presentation is that, of course, closing the borders to some extent can protect you from it, right? So the free capital flows, the free, entrance of any kind of legal creatures that take the laws that they're governed by them with them, that makes it almost impossible to do local mobilization for change, also at a legislative level. So I think, but given the kind of the political situation, the political, geopolitical, and economic situation we're in, I don't think that transformative change will come from above. The Biden's IRA that's trying to do something for climate, well and good, mobilize billions of dollars, it's dead in the water now. It was very short term, right? So we have to be even more imaginative. And it also used, of course, the classic tool of credit finance, which is a risky tool and puts also many people in debt. So, you could even take that apart and say, is that what we want? One of the fallacies, I think, of capitalism, I said this at the beginning, is always about the future, trying to monetize the future already and make money on it today. That's so anathema to doing something about climate change, right? We've basically bound our hands for decades to come to pay back our debt for investments that we shouldn't materialize anymore because we're in the midst of climate change. We shouldn't be doing it, and yet we are. Right, so you probably saw also Trump, I saw this in the FT today, he said that he will force the Europeans to buy gas and oil from the United States or impose tariffs, right? So if we're in this world, you can't really trust the states. But I don't want to rule it out. And I think that if there's more social mobilization, the likelihood that there will be more transformative change also coming from the top will increase. Thank you.
So questions?
Hello, thank you very much for the presentation. I am Zulfia from Azerbaijan. So first of all, I want to say that disclosure, I don't have much of a literature of law, but to my perception and understanding, I was always thinking that the only probably benefit that is this individualized tendencies brought probably is human rights and individual rights in front of the court, because even if there is no a collective group, a big group of people whose rights are violated, and if you are the only one that experienced something very harsh towards you, be it torture or other things, you still have a right to claim that your rights have been violated. And when you mentioned that actually, according to Levy, private law was existent even before democracy was existent, I started to question whether my assumption was true or not. And I wanted to ask you, what do you think about this? And do you consider individual rights of people as a contribution of individualist approach to law, or it's more of a public law? Yeah, thank you.
Okay, we collect 2 or 3 questions. Okay. Say this.
Yeah, thanks from me too for the presentation. Really fascinating. Friederike from Germany. I mean, it's kind of a bit implicit in your presentation too, but I was wondering about this international versus national dimension, right? So we have mostly national laws, obviously also some supranational, international constructs, but really a lot of like dominance of multinational firms. So I guess like on a higher level, it's a bit of a no-brainer how to connect it to your framework, but I was wondering if maybe in the book you could go a bit more into detail about like what this tension between international firms and national lawmaking means in capitalist law, and also how it's maybe like a new form of international capitalist law versus the more national approach that we maybe had like a couple of decades ago. Thank you.
Hello, thank you for the presentation. Daniela from El Salvador. And I just want to focalize again on this, like going beyond capitalism or capitalist law. And I just want to understand better, how do you understand the change of causality in this sense? Because maybe I have a bit of a Marxist bias, I will say, but I have a hard time perceiving like a radical systemic change or a radical transformation that will not hang on like a materialist notion or a material change per se, especially because in a Marxist framework, the material change also entails like social transformation. So I want to understand the causality in that sense, because yeah, I don't really see it, but thank you.
Hello, thank you. I'm Jan from Germany. I had a question about the role of the state in like transformation away from capitalism, and also in general in the control of capitalist law. So, and I'm talking not about the state as an abstract category, but more like also the current state, like how the state is currently configured. Is the state even powerful enough to or has the abilities to code the capitalist law? And if not, how can the state maybe also regain some more power over multinational firms, for example?
All great questions. So on the first, yes, and it's really an important question, and one can debate this at length. There has been over the last couple of decades a lot of critique of these subjective or individual rights that we associate with the epoch of the Enlightenment, and with individual freedom and also more respect, human dignity, all the rest. So this is overall positive, right? I think many liberal philosophers would also say that sort of the separation between those kind of individual rights and whatever is collective, between the private and the public, is essential for an order by which we want to protect ourselves against an overarching state. And I think especially if you come from Azerbaijan or if you come from a former socialist countries, that's what you're holding on to, because that's also something that did not exist in the real existing socialism as we knew it. At the same time, the critique of these individual and subjective rights has basically said, first of all, they have been adopted and abused and transformed by corporations for themselves against others. So you use your right to property, the right to organize yourself as an organization, the right to be a person, to dominate others by using a contract which is between formally equal persons, and you can basically have similar forms of dominance that try to pretend to be within a framework of rights and respect, but in fact are not because of the different resources. More than that, they basically entrench a particular order. Then once people have manifested their specific rights, it doesn't necessarily mean that they give them to others. So you would have to depend on state enforcement mechanisms to give others similar rights. So one of the solutions to that, Christoph Menke, for example, in Germany, has suggested that these subjective individual rights should be more temporal, that you have rights for time, but not forever, because the tendency is to use these rights to then build your empires against others as well. There is, and I think this goes back to Pashukanis again, he's basically saying there's a fundamental tension once we bring these private rights into a public order, once we pretend to be a republic or maybe a democratically governed republic in which we want to maximize, yes, the rights of individuals, but at the same time say you are part of a democratic collective. within which you make decisions. So everybody has to give a little bit, right? You can't maximize all your rights. You have to sort of come to a collective decisions. In that kind of context, this becomes a tension if some can always assert their rights. And what I'm trying to say here is the private legal order still tries to assert itself as an absolute individualistic legal order without the constraints that come from being part of a collective. There are, again, always exceptions to the rules. So Germany, several others here are from Germany as well. There is a constitutional provision which says property is an obligation, not only a right, it's also an obligation. And the contents and scope of property rights are defined by the legislature. When I tell this Americans, I think we're completely nuts and we're total socialists. But you can have a capitalist economy with these principles as well. The US Constitution, as most others, simply say the right to property is guaranteed. Doesn't say what it is, doesn't say who holds it, doesn't say you can grab it, you can grab that right. That has happened. So there's no yes or no answer to your, and I could go on and on and on. You just see that this is the tension that we have to deal with, and that we can't really disentangle it. But once we recognize the tension, then we see that the answers are not so simple. That's what I would say. Second question: national, international, legal. So I come to this as a private law person, as you can tell. I teach corporations, I do teach finance and stuff like that. So I look at the world from inside out rather than top down. So I think I would describe our transnational or global legal order as one that is mostly built, especially when we talk about economic order, it's mostly built with a few domestic legal systems that have become portable, right? So it's very hegemonic. Most internationally tradable assets are coded either in the laws of the UK or the US. English common law or New York contract law, Delaware corporate law. This is basically when globalization means the expansion, portability of these domestic legal orders, because everybody adopts it and every state recognizes them and makes them enforceable in their legal system. International law has supported this to some extent. International law can be, of course, these are treaties between the subjects of international, which are states only, right? Corporations would like to be treated like on par with states. That's especially when it comes to investment state disputes. But they do not want to have the obligations that come from being a full subject of international law. They've always resented this and they don't want this. And we have the UN Charter, which is a watered down attempt to try to subject multinationals to some kind of international law principles. And it hasn't really brought much result, I would say. Because again, I think the multinational corporations, they use domestic private law to build their empire, and then they get support. They get support from states in the form from bilateral investment treaties, bilateral trade treaties, NAFTA or its successor, which basically says 2 states give a private multinational the power to sue their host state where they do investment in an arbitration tribunal outside its territory to just enforce the law, nothing but the law, and of course the law that they have been able to kind of influence themselves, to a point that actually one of my colleagues calls them international lawmakers because they can pick and choose the treaty by which they wish to be governed. So public international law has done some good, has provided, of course, the International Sales Convention, the New York Convention for the Enforcement of International Arbitral Awards is a double-sided sword. It is used as a helpful tool. It's not capable of shaping this order, because this order is being shaped by more powerful tools, is how I would answer this question. Number 3, capitalism and capital, change, causality, economic and social transformation. Where was this? Was you, more from a Marxist point of view? Yes, of course, the idea is that kind of the economic condition, let's say we socialize the means of production, right? Okay, so of course today we would have to think about this very differently from back then. We just don't put some local Soviet or even the state Soviet in charge of a factory, but we would have to think about technology and how you would socialize these different things. But what I'm basically saying, first of all, you need also big institutional apparatus to do any of this. This doesn't happen like that. So it is an institutional and legal transformation. You can't, if you say this order that we have, based on private property rights and this legal system, you have to change that system. Can you dismantle it from today to tomorrow? I don't think so, frankly. And I think a good example for that is actually, I spent the 1990s working mostly on the former socialist world. So when you transform an entire system, I spent some time in East Germany, coming from West Germany. You go to East Germany, they basically said most of the law does no longer exist here. And then what do? What exactly do you do? After the Soviet Union was dissolved, they basically said, Soviet law no longer exists. And then within 6 months, they had to say it does exist, because otherwise you can't govern your affairs. UK leaves the European Union, says we want to get out of Brexit. The first thing they do is they make all European law British law, so they can then dismantle it as British law without having to go through treaty. So it's such a complex system, and it determines so much of what we do that you can't do it without there. We can have a difference of whether you also have to do the materialist condition. Yes, but these materialist conditions today, I think, are so deeply coded in these kind of relations that without it, it's just impossible to do. So Marx might have agreed, but he didn't live long enough to see our world today is how I would put it, but we can disagree on that, it's fine too. The role of the state in the transformation of capitalism. First of all, it's not the state that codes capitalist law. The state just makes certain legal principles available to people who can code their own legal system. So when I talk about code, I don't mean codification. So the codification is like the Code Civil or Bürgerliche Gesetzbuch, etc. These are legislated codifications of law, also existing law. The French used the common law that was around at the time and then put it in a code, and the Germans did too. So it's not just a new invention. But what I'm talking about is basically now you have these codes, either in case law or in codified law, doesn't matter. If you know how to use them, you know that you have private autonomy granted by the state, you can write your own contracts. You can create a new business organization. You can create new financial instruments. You need no approval, nothing. You just do this in the expectation that it will be enforced. Now, once you are in front of a court or once a regulator will strike it down, then you have to prove your case. And sometimes it will be struck down. But in the meantime, you can actually make a lot of money, and that won't be clawed back. So the coding happens actually in the private sphere, which is also why I think that's where actually change has to come from. There's a lot of power there that is underutilized, I think, by non-capitalist forces, if you want, where you can actually recode relations without having to reinvent the entire legal system in a way that's highly centralized and might still be compatible with the institutions that we have. Now, how powerful is the state today? You know, it can be quite powerful. Think of COVID. States also in the West, even in the United States, they just shut down entire economies. And they gave everybody food, basically, directly or indirectly. Now you can see also how weak some states are. In the US reaches individuals out there only through the tax or through banks, and if you don't have a bank account, you're out. You know, if you're poor, you don't pay taxes, and you don't have a bank account, forget it. In Europe, you might still find other ways that the state can even reach you, right? So, but that's what states were able to do, and for quite some time. And I think this gives us also an idea that under the right political circumstance or right threat constellations, there might, right? But there are kind of also unique factors in place here, so I wouldn't overplay it in general. In general, states have given up a lot of power by opening their borders, free capital flows, by committing in the interpretation of treaties, right? Once the European Court of Justice says capital flows, even with regards to third parties, must be open, otherwise it's a violation of the fundamental treaty principles. It's hard to get out of that. It's really hard to get out of, and states are bound.
Okay, start and then we...
Thank you very much for your talk. I'm Lucien from the UK and France. I think there are a lot of subtleties to your argument that I completely missed, so maybe my question will be very basic. But one element that I was a bit confused about and I would like a bit more details on is like the enforceability of law, and especially looking at it from an international perspective where you have countries with constitutional rights and provisions that are not at all enforced or implemented. And then obviously you've given, I think, elements of an answer to that already by recognizing the hegemony of the international system. But yeah, if you could just talk a bit more on that, please.
Yeah, hi, I'm Thomas from Norway. Yeah, my question is a bit related to what Daniela just asked. I'm still not convinced that the law is so central to capitalism, or at least that you have to change it to the legal system to go beyond capitalism. And I don't know, I would instead argue that the social and material conditions determine what the law is used for. For instance, and that huge changes to capitalism and even abolishing it could be possible without doing fundamental changes to the legal system. For instance, you mentioned Sweden and collective bargaining, which I think is a good example of a variation of capitalism that is actually very different. Unlike, I would disagree on you in that. I would say that it is, with collective wage bargaining system, is very different and also could pose a threat to capitalism. And it, as we see in the 70s and 80s, there was a wage earner fund plan, for instance, which was a serious threat to capitalism, and that it didn't fail because of the legal system, but rather because of the raw power of the capitalist class and their control of the media, etc. Anyway, this system was created by a contract between the employers and the unions in the 30s. And so it's a legal contract that kind of created the system, but this contract could never have existed or come into place without the power of the workers, the materialist conditions, the threat of a revolution, etc. So wouldn't you agree that what really matters is the material conditions?
Hi, I'm Lou from France. I think why maybe a lot of people have a hard time thinking of law as something that can bring radical change, and you mentioned it, is time, is because we have this vision of law as something that is really hard and takes a really long time to change, and you say that law is actually not really static and it's changing all the time. And I thought the Nigerian example was interesting, and I wanted to know if you could give us other example, especially in the context of the climate crisis, where we all feel like we're running out of time. If there are ways then we can accelerate these processes. I know you mentioned the state putting it into their law. I know there are climate activists suing their states too. I think that's interesting cases to mention, so I wanted your opinion, maybe more examples on this.
Hi, Timon from Germany. I rather have like a clarification question, because you said at some point that public law had issues implementing private law. Isn't that contradicting then with Pashukanis what you then said, like that every law is private law? And could you maybe give like a historical example of this? This would make it easier for me to understand. Yeah, thank you.
Some reply and the last round after that.
Thank you. Enforceability of law in international perspective, yes. So yes, many states don't seem to have the capacity to enforce their law. Is that what you have in mind? And many people don't get their rights enforced, and might also actually have a hard time then accessing international tribunals, like international or regional human rights tribunals, etc. The beauty of what capitalist law has been able to do is basically creating its own tribunals, right? You create arbitration tribunals outside states, whether for state investment disputes or for your private commercial disputes. And by way of the New York Convention on the Recognition and Enforcement of International Arbitral Awards, which was passed in 1958 to revive global trade after World War II. But this convention basically is now used to say, if you have an arbitration award rendered by an international arbitration body, the states that are members of this convention will have to enforce this through their regular courts. So you then have to you get an arbitral award, you have to find a state within which there are assets of the losing party against which you can enforce, and then you mobilize the enforcement powers. Now there are states where you're helpless, where you can't do it, right? So, but there are states where you can. So the question, this is then basically, if you have to find assets in the state where enforcement capacity exists. But once you have a more pluralistic legal order, you can basically pick and choose as long as you can find assets in the state that's kind of functionable to you, and that makes it more powerful. We all, as ordinary individuals and persons, we're basically nationals of a single state. we are subject to that legal order. If also under international human rights tribunals, if we have any issues, we have to exhaust the legal remedies in our own jurisdiction before we can go to a transnational legal order and get anything enforced at all. You don't have to do this when you already have an arbitration provision in your contract. Neither do you have to do this under the estate investment dispute resolution. You go straight to arbitration. You don't even bother with these courts straight, and you use them only for execution. So it's essentially states are renting out their enforcement capacity to people who use arbitration, with ramifications for local legal orders, but I'm not going to get into this because I know that we're short of time. Social material conditions, why don't I agree that I'm not saying social conditions don't matter. I do think that if you have the threat of strikes and revolution, the idea that you do something that creates like a collective contract that changes the world is much more likely, but without the contract, you're not going anywhere. So yes, social mobilization to change the rules of the game, but what is at stake to keep a social order in a particular way or for it to tip into a different type of legal order are the rules of the game. What I'm trying to say already in the Code of Capital and in this book again is that when powerful actors, can be private and public, but I'm also saying powerful private actors can change the rules of the game as the game is being played. Think of soccer. We're playing soccer, and as the game is being played, the players themselves, the most powerful players, are changing the rules, and the umpire will enforce those rules. That's what capitalism is all about, right? So yes, you can talk about whether you want to have a bigger soccer game or smaller ones, and you can change the goalpost, do all kinds of things, but that is the core power. And I think sort of in the ability to scale these rules, both on the good side and the bad side, that's actually what keeps systems in place. You need mobilization, but I think that's basically, for me, that's a starting point, but you need the rules of the game. And that I call law, you can call it something else, but we have to have collective expectations about how we want to play with one another. That's what norms, rules, other things in the end do. But it might just be like, it's a little bit of a chicken and egg problem in that sense. You can't do one without the other, but I don't think you can sustain it over time without these rules. And now I've put my head out there. I will not budge on this one. Can law bring about radical change? Yes and no. So I had an interesting debate. Some of you might have heard about her, Joanna Kuziak, who is a sociologist in Cambridge, and she's from Poland originally, and she looked at privatization in Poland and how the law was used to make some people really rich and leave others out. And she lives now in Berlin, also has become a German citizen, and she has been at the head of the referendum in Berlin to re-socialize housing that has been privatized, right? And she uses a term that I like a lot, which is called trespassing on the law. If you want, basically, capitalists have always trespassed on our public law that was used for creating democratic citizens. They've always used it if they were able to use it for themselves, but not necessarily respect it. Trespassing on the law is something similar, and she points out to the German Constitution, which has an Article 15, which says socialization is possible. And for compensation, but you can of course think about how much, but socialization, not only privatization, socialization of land, of social goods is possible under the Constitution, has never been invoked. But they had law and opinion after the other has confirmed that it's still possible, this article still exists. And they did a referendum in Berlin, they're doing a second one. That's what I mean. You can actually, there are sometimes hooks in the legal system, you have to find them. Yeah, there are hooks in the legal system that you can use for change. Now, will it be transformative? You can see this only from hindsight. You can't see this at the outset. As I said before, you can have sustained transformative change only if you have rules that govern this. Katharina Thelen, again, to come back to her, she was quoted by our commentators here, she has done a lot of work with people showing that contrary to what the economists think, typically institutions are there, they're sticky, and they change only incrementally. We're always on the same path, right? Path dependence. She has shown in a lot of her work with others, mostly people working on European issues, that incremental change can be quite transformative. So if you push this without formal change, you can use the existing rules of the game and you can push them into a different direction. Happens all the time, daily, in all kinds of things. I come back to climate change, but they're using examples from the pension system in Germany to labor rights in Scandinavia and all kinds of things where you can see that by reinterpreting existing rules and having different actors using them, they change quite radically in the end. And just to come back to Joanna Kuziak, her book that she published, which is openly accessible, you can just download it from the internet, it's really a fun read because it's written just as a fun book, not an academic book. It's called Radically Legal. So if you don't find my answer successful, then just read her book, Radically Legal. More examples, climate crisis. Shell is, of course, just one case. I've talked to quite a few environmentalists. I have to say that's also a bit sobering. So Mexico, they have done lots of things on that level, local, basically using the law to win cases. What happens typically in step 2 is that the other side mobilizes all the resources that they have to fight back and change the law again. So it's not necessarily even the Shell case might not be the precedent that will win. There will be a lot of pushback. And with the resource that the others have, a lot of this stuff will happen. I also agree that by criminalizing climate activists doesn't help, but this is where the states are, right? This is where the state is cracking down to keep the order that we have in place by cracking down on the climate activists. I still believe that there is a lot of scope for change, and that also, again, more is happening under the at a lower and local level. How to manage common pool resources, Elena Ostrom work has done a lot of that. We see similar stuff happening under crisis situations, climate pressures. When the Colorado River Basin is drying up, somehow the farmers and the adjacent states have to come to terms with this, or this whole ecosystem and the economy that is built on it will collapse. These kind of pressures sometimes force change. You can say it's too late, and unfortunately that's probably sometimes the case. But under certain conditions, you can see people stepping out of narrowly defined rights and trying to recreate new ways of interacting with one another. Again, ironically, it's the same stuff that Elena Ostrom started her career with when she talked about polymorphic or governance systems in the arid west of the United States. And last but not least, a clarification, private law, public law, difficult enforcement. I might have misspoken. I mean, the state courts, of course, enforce private law. Right? That's not the point. I think what I wanted to say is that within the public law framework of having individual rights, the subjective rights that we protect under constitutional provisions, the private law idea of my right is my claim, and I will fight for it no matter how, sits not easily. That's the antithesis. So Pashukanus doesn't say this goes together. Pashukanus says there's an antithesis. There's this duality of these two legal systems that is driving capitalism. Clear divides, like he starts basically in the cities of the Middle Ages, where he says, when you separate property from tax, property is private, tax is public. That's where it starts, because now I'm protecting my property against the tax levy. We are always fighting over this. We're always fighting about our individual claims against a public that we, of course, decry as a state. That's always dangerous, but it's the public that is trying to have some levy on private goods to fund common goods or public goods and things like that, right? That's where the tension lies, in this friction.
Last round of questions. Okay.
Hello, my name is Marie-Noël. I'm also from Germany. Thank you for coming here. It was very interesting. So until now, I have understood you more that it's not about the code in a written codification sense, but more of the power over the code and the practice of law. And so one could say that also only looking at the words, one could interpret the words differently. So this brings me to my question about the role of socialization of lawyers and the training and formation of lawyers, and how this fosters a certain belief that law is neutral and that they end judges and arbitrators, as you said, end up on the wrong side. And if you see also the formation and the training as like a starting point to change the system.
Yeah, I'm Antoine from France. I still have trouble to make sense of which actors are involved in, let's say, the enforcement of the law. You said, for example, if I'm not mistaken, that enforcement of law or law can be changed through grassroots movements. But like, if we talk about parliament and enforcement by the of law by the state, by parliament, we have many obstacles. We can have like I don't know, corruption, police, or anything. So I wonder what you mean by changing from grassroots movements and what actors, in order to map more the actors.
Hi, thank you so much for this. My name's Haley, I'm from the US. I guess, and it's okay if you just want to touch on it briefly, but in terms of different prospects for transformation, it came to mind some cases where rights of nature have been enshrined into law, and I was wondering, if you can kind of let us know your view on that. I know there are a lot of limitations to the actual court cases that have been brought about, but at the same time it is kind of a shift in how we're considering, you know, who gets rights, and so I was keen to hear your thoughts. Thanks.
Thank you. So yes, the socialization of lawyers is key. I gave the same talk to a group of students at Columbia, and one of my students said, and why are we still learning the same crap, essentially? And of course, what we are doing at the law schools, we're making sure that you pass the exams that make you able to sustain the system, right, that we have. That's the authority of the law, and that you have to enforce it. I would say in the United States, you could say we're more realist, sometimes even a bit more cynical. The overall, the arch of legal education, especially in common law countries, and particularly in the United States, is to treat the law a little bit as a tool that you can use in different ways. And you learn this from the get-go. So for me, it's actually more important to enshrine the legal training again with some normative stuff, which is it has had traditionally also under the common law, the equitable principles of contracts. So when I said they use the duty of care in the UK case against Shell, that's an old principle, and that is basically if you are, you know, you basically have to treat others like you would treat your own stuff, and you have to take care of the agents that you employ, and you have to respect. These are all things that did exist in the law that one could highlight again. I think they have been stripped out of a highly positivistic utilitarian view of looking at the law. I would say that in the US we're particularly constrained in changing things. Our students pay right now about $80,000 a year for a 3-year training, and so they come out with roughly $400,000 in debt. And so they basically don't have a choice but to code capital to get out of this debt. So that's a system that I'm a part of, that we're recapitulating in this particular way. Having said that, I would say even in Europe, the attraction of money attracts many people to the top firms, where they make a little less than they would in the United States, but of course that's the choice. And at the same time, you see also other stuff. It's always on a smaller scale, but I also like to look there because I tend to be a more optimistic person. So some students at Yale started a couple of years ago, and that's our #1 law school. So they started a couple of years ago to draw up blacklist of firms that are always on the other side in environmental disputes, that always defend the polluters. And say, we just don't go there. So if you come from the top law school, and of course there's firms trying to recruit at the top law schools, these students commit, we're not going to any of these firms. And they make this published. You get an A to F ranking of the firms out there. Now, we've talked about this with a practicing lawyer who came to a session, and she basically said, you know, there is a tipping point. You never know when it is, when law firms will stop doing certain things. So in the tobacco industry cases, when there were enough cases against tobacco, at some point nobody would touch a tobacco company anymore. And to some extent, you have to bring it to a point where nobody touches an oil or gas company anymore. And these are first steps. And again, they might be slow, but I think this is the mobilization again, right? But the lawyer saying we're not going to do their dirty work. We're going to do something else. And there's lots to do on the other side. So I congratulate them. Okay, socialized, yes. Actors involved in law enforcement. Who was this again? This was, yeah. So, yes, but law enforcement always the ultimate thing that you have to think of, and I think the idea that something will be enforceable is critical already ex ante, not only at the final stage. But if we had to basically bring every case of a dispute or every conflict or every lack of full compliance with the law to a court or police, the system will completely collapse. We already know now that most small claims will never be enforced because it just takes too long, and by the time everything has been settled already otherwise, right? So the idea that this is a hierarchical system that everybody actually brings a case to enforcement is naive and silly. I actually recently had somebody from the World Bank, she came to my office and she first emailed me and said she wants to talk to me about a new World Bank report, and I said, I think this is a waste of time, don't come. Then she says she still wanted to talk to me, and so we talked. And they're basically thinking that they want to empower poor people in developing countries, that everybody has access to the courts to fight corruption. And I said, you know, it doesn't work in the United States. Why do you think Ethiopia will be able to afford everybody going to court? This is not how it works. At the same time, many of us, even if we don't expect to go to court and will never do so, we're still writing contracts. We're still writing contracts. We might just do a handshake if we know somebody, but we might write a contract if we rent a place or rent a car or lease something out, right? To regularize our relations, and if in doubt, to have the threat to make something enforceable. So legal systems are much more decentralized already, even in France. I think, again, the UK, the common law systems are more extreme in that, but even in the civil law countries with these centralized codes and the idea of this is everything through the legislature and only at the back end through the courts, a lot of stuff happens just in private practice where we rearrange and rewrite, whether it's a will for an estate, whether it's the family relations that are being renegotiated as people separate. There's so much happening where actually legal documents are being drafted, where no police, no court, no official is involved, and yet it has become like the language within which we do somewhat more complex transactions. Everything else will be by handshake, but don't underestimate how much, like every day you click agree. Every day you click agree, you're signing pages and pages and pages of contracts automatically. Different prospects for transformation and rights of nature, yes. So again, this happens on multiple levels. So the most publicized in the press, I think, is when you have a constitutional change like in Ecuador and some countries that say, we're now protecting the right of nature. That's great. The question, of course, is who will enforce it? And that's where the things start. And what is the weight given to nature against other rights, right? So then you pitch them against each other, and then you are, this is again what Preshokanos would say, this is the antithesis, pitching the different rights against it, which one will win in the end. Nonetheless, I think it's an important step, in part only because it changes our minds. So here law can also change our minds, basically saying we're just endowing nature with the right. Why not? Some people say, well, you can't do this is not an animated thing, But corporations have rights. Corporations have rights. They operate through human agency. Nature can also operate through human agency. So yes, it's possible. I've talked to a couple of practitioners who've started to create rights of nature through private contracting, basically through trust instruments, trusts and contracts. So they basically incorporated a river, a forest, and I don't know, some wetlands separately, and they all became stakeholders in a piece of nature that was circumscribed. It's zoned, so that's that nature. These different associations, yes, they're abstract, but we deal with abstract stuff all the time. Banks, hedge funds, PE, all abstract things, right? They're also, why not nature, right? And you start writing contracts for them and then enforcing their rights also in private law. And I think this duality is important because so much happens in the private law sphere that is, violates rights of nature and others, that trying to use these tools for advancing nature's and all of our interests is also important. Could be abused, I don't want to rule that out, but it's also an important strategy.